morning, everybody. My name is Laura Scott. I am a public and private law children law specialist barrister. I was called to the bar in 2001. I work a lot with young and vulnerable parents and interveners in care proceedings, as well as representing increasing numbers of teenage subject children in both care proceedings, dolls cases and private law. And today my talk is about child criminal exploitation. So let's get that first slide up. So what we're covering today, you can see there, we'll look at various forms of criminal exploitation, the role of social media, some statistics, go through the risk factors, have a look at some guidance and resources, and look towards the end at what we can all do when we're concerned that there may be exploitation, and help to raise some awareness of this issue. CCE is a really significant issue. There's a widespread lack of understanding of it still. There's no single comprehensive strategy for prevention and protection of children that are at risk of or being subjected to exploitation. The emphasis on child protection measures requiring parental failings is outdated because children from all walks of life are vulnerable. In the last 18 months, I've represented several fathers and interveners in care proceedings, and of those, only a small handful have not had some involvement in child criminal exploitation. And of those individuals, not all of them are young people. A child being beyond parental control doesn't require unreasonable care from a parent, but the child protection model has been based around harm from within the home for so long that it's taking time for the focus to shift. The reason I wanted to look at this today is because as family law professionals, it's really important that we are alert to these issues to make sure that the right support is provided at the earliest opportunity, and to support parents whose children may be involved or may be involved themselves as victims of exploitation. We're used in child protection to the push factors that can lead to children ending up in criminality, coming, for example, from negligent or abusive homes, that pushing the child out into risk-taking and criminality. But what we need to be more aware of is the pull factor that are present, that are enticing children out of homes where there might not be those other issues in place, but it draws the children into criminality. So we can see on the slide here the definition of CCE. There is still no statutory definition of CCE. This has been a problem for some considerable time now. What I've put up here is a combination of a couple of definitions. The body of the text is from the serious violence strategy from the Home Office. That's not been updated for some 6 years now. And what's in bold and italics is what's been proposed by the J Review, which came out in March of this year. And that's their recommended statutory definition. Why do we need a statutory definition? Because the problem with not having one is it leads to different interpretations of what CCE is. A statutory definition is also needed, the J Review says, to create a new offence, because at the moment it's only through modern slavery prosecutions under the Modern Slavery Act 2015 that prosecutions can be brought, and that also is where the defence to crimes committed whilst being exploited comes from, but it's really not straightforward and it lacks understanding of what exploitation involves. there is increasing attention being given to criminal exploitation, and that's necessary because of the sheer scale of the problem. There are absolutely huge numbers of children and young people that are being drawn into gangs and are being exploited. The Children's Society cites that there are something like 46,000 children in England alone thought to be involved in gangs, and that is believed to be an underestimate. There's real difficulty in knowing when a child is caught up in exploitation. There's also a real misconception that this is a problem that's limited to low socioeconomic communities. All children are vulnerable to it, and we're going to have a look at some of the risk factors. Currently, child protection systems are still slow to recognise and address exploitation. It can happen very quickly, and it can lead to a child or a young person being trapped in a cycle that they can't get out of. So let's take a look at some of the forms of criminal exploitation. The J review that I mentioned a moment ago and we'll have a look at in a short while explains that it takes a range of forms, including dealing and transporting drugs or weapons, including county lines, growing cannabis, theft and burglary, street crime such as begging and pickpocketing. Exploited children are often experiencing multiple types of abuse at the same time, including violence, threats, emotional and sexual abuse. I spoke on county lines a year ago in the brunch, and we'll make those slides available for anybody that wants a little bit more information on county lines. It's the term that's used to describe gangs and organised criminal networks that are involved in exporting drugs into one or more importing areas within the UK, using dedicated mobile phone lines or other forms of deal line. They're likely to exploit children and vulnerable adults to move and store the drugs and money, and they'll often use coercion, intimidation, violence, including sexual violence, and weapons. It's a really sophisticated and constantly evolving business model. It is not limited to large cities. The central areas involved are Merseyside, the West Midlands and Greater London, but the business model is to take particularly heroin and crack cocaine into smaller towns around the country. Children and vulnerable adults will be recruited from cities to take drugs out to smaller towns, and also now they will be recruited from those smaller market and coastal towns to go back and forth to cities. They use the public transport network and taxis much of the time. And the statistics for this are really concerning. The county line closures for 2021 to 2022 were 703. For the following year, there were 1,364 line closures. The estimate a couple of years ago was that each line generates approximately £800,000 a year. It's a huge business. Cuckooing. Cuckooing is where a property is taken over by an organised criminal gang. It's used for gang activities, drug preparation and dealing, storing drugs and money, parties where children and young people are coerced into sexual activity and taking drugs. And often the occupier of a property might be forced through debt bondage or grooming into believing they're in a relationship or friendship with a gang member. Plugging, really unpleasant. This is coerced internal concealment, using a child or a vulnerable adult to transport drugs or SIM cards or the like. These items are inserted, often forcibly, into a body cavity or swallowed. There's a really alarming case study from the British Transport Police in the Home Office County Lines guidance, which I'll look at in a moment. Victims of plugging often suffer serious physical harm and often need immediate medical treatment, not to mention suffering psychological harm from that particular form of exploitation. I've added sextortion here because there's increasing amounts of press about this, and it's something that certainly seems to be making its way through society and affecting children from all sorts of different backgrounds. This is a form of blackmail where the child is tricked into sharing intimate images of themselves, or their phone is hacked and images from their devices are copied, or fake images are generated of the young person through Photoshop. Just to mention that the use of Photoshop with images obtained online is really widespread. The child will be threatened with needing to pay money. Otherwise, the images that have been obtained or created will be shared with everyone in their contacts. This is a form that is happening from within the UK, but because of its online nature, it happens from gangs abroad as well. As I've said, photo manipulation is a real problem. I include sharenting with this. Please think twice about putting any images of children online in any form. Knife crime. Criminal exploitation seems to be little reported as regards knife crime because the violence of itself tends to be the focus. But the explosion of exploitation and county lines has created a culture for children where they feel they need to carry weapons. Knife-related crime in the West Midlands is shooting up at the moment. It's been growing since the pandemic. It seems that there's a really widespread availability of weapons. They're seen as fashion statements. Social media is being used to sell them. Children as young as 9 are carrying knives. There's reference in one article from The Guardian of 12-year-olds thinking like 18-year-olds. The fear of being caught up in rival gangs because family members are in gangs. They have a kill or be killed mentality. There's been a 20% increase in knife point robberies. Snapchat, TikTok, and Telegram are all used to share these weapons. And when a child searches for a weapon, algorithms are offering them even more. And there is preference for large knives to be obtained because it intensifies the terrorizing effect, especially those involved in the drug trade. Financial exploitation and debt bondage. Once somebody has been lured into exploitation, various tactics are used to lure them deeper into criminality. For example, they'll be told to hold drugs or money, and then the gang will deliberately steal those goods from their victim and make them complete further jobs to pay back the debt. I'm going to try and race through these slides. There's so much information to try and share this morning on this issue. So I'm going to whiz through these slides that will be made available for you. Social media plays an enormous part in CCE. It's used for recruitment and for monitoring victims' whereabouts. Professional adverts are being placed on all of the major media sites. You can read there how that model works. And it also comes through smart TVs and gaming consoles. And the information that is obtained about young people through social media makes them really vulnerable. The gangs can find out about younger siblings, for example. We know where your little brother or sister goes to school, we're going to hurt them. It also makes befriending children really easily, as well as enabling that information to be used against them later. 150 different apps, games, and websites have been identified as a means to groom children. Some statistics here. Nearly 7,500 referrals for children made to the National Referral Mechanism, enormous increase in that since 2021. 14,500 child in needs assessments recording CCs, a risk of harm. Numbers of children being killed, majority by being stabbed, increasing, and the number of offensive weapon and drug possession convictions of under 18s are going up. Looking at the risk factors, there's a really excellent review, research document rather, from Nottingham University and ECPAT that goes through a vast number of risk factors. And it will often be the case that these risk factors combine to increase vulnerability. Children are inherently vulnerable because they're easy to manipulate and to control. Under ACE, Adverse Childhood Experiences, I've included divorce, DV, and what have you there. That is not limited to children who might be subject to child in need procedures or care proceedings. Children suffer trauma by going through their parents' breakup, including when they are taken through private law proceedings and subjects of private law proceedings. Continuing the risk factors here. Many of them are push factors, but you'll see towards the bottom there, the pull factors here, the sense of status, belonging, and protection of being groomed are enormous draws for young people who feel disenfranchised, who are living with huge levels of poverty. And desensitization, this comes not only from being subjected to ACEs or trauma generally, but also witnessing violence within the community, and arguably also from the television. There's a lot of distressing information that is on the news these days, children exposed to really upsetting adult content on a daily basis. And I think we've all become a little bit desensitized to that. Signs of exploitation. I've put several pages of slides here because there are just so many things to try and look out for. Sudden changes in behaviours are always a red flag. New money, new clothes, new phones. Obviously, finding weapons, drugs, paraphernalia, train tickets for unusual train journeys, bags that can't be let out of the young person's sight. New relationships with older people, apparently being controlled or starting to spend time with a group that they weren't previously friends with, and importantly, in conjunction with isolation from their usual friends and networks. That's an important tactic of the gangs, to isolate their victims. Changes in appearance, including unexplained injuries. These do tend to be visible, that can be quite minor injuries that are issued as a threat, like cigarette burns or small cuts, but it can obviously be much more serious. Excessive amounts of time online, excessive sharing of personal information, sharing money, gifts, gaming tokens, and what have you. Signs that a property is being cuckooed. You can see there the various signs to look for here. And I would say that these are things to not just be aware of when we're working and concerned that CC might be an issue in our cases, but these are things that we can be alive to within the community generally. Coerced internal concealment, plugging, young people refusing to eat or drink, and the other signs there, all things to look out for. Financial exploitation and debt bondage. Again, opening new accounts, unusual transactions, dealing with sums of cash or transactions that they don't seem to understand, asking for money, stealing money and items, all those behaviours that can sometimes start quite suddenly. Moving on to the guidance, national referral mechanism. Local authorities are amongst the first responders that must refer any child they suspect to be of being a potential victim of modern slavery, which includes obviously criminal exploitation. All of the information is about that online. I've put some references at the end of this presentation so that you can click on the links and find all of this. If you think an adult might be a victim of exploitation, you need their permission to make an NRM referral. Otherwise, you need to do a duty to notify. The Home Office Disruption Toolkit is still a really good document that sets out guidance and sanctions and support, as well as location disruption and how to recognise where exploitation might be happening in a community. A new document from October of last year is this one from the Home Office. It's a really, really helpful document. It's just 24 pages. If you're interested in this area, I would recommend just having a copy of that available, not least because it's got a good list of resources at the end of that document, but it goes into a little bit more detail of the things that we're looking at today. The importance of trauma, the importance of us trying to effect trauma-informed responses wherever possible. I would encourage everybody to look into that. Contextual safeguarding. This is not used as a reference for whatever reason now. It started nearly 10 years ago, but now it's known as extrafamilial harm or extrafamilial threats. Working together, new guidance came out last year. There's emphasis on always considering whether there is extrafamilial harm present when you're conducting risk assessments, and also ensuring that holistic assessment is completed. That includes looking at the positives of the young person, because forming relationships with children, young people, vulnerable adults and parents is absolutely key to helping deal with this issue. Just there, some of the headline points from the J review that came out in March of this year. I'm really encouraged by the number of research documents that are coming through currently. It's clear that this issue is rising to the surface a little more now. I've already mentioned the ECPAT and Nottingham research document. You'll see that there's a lot of common features between all of these guidance documents. The importance of multi-agency collaboration, There's also new Keeping Children Safe in Education guidance on its way. The draft is online at the moment. I think that's due to be finalised in September. Information sharing, just before we finish, I want to mention the importance of this. There's the 7 Golden Rules document, which I think I've also put the link to. And rule 1 of that is that protecting a child from abuse and neglect takes priority over protecting their privacy or the privacy of the person failing to protect them. This is a GDPR exception because it does seem that concerns about information sharing and concerns about protecting privacy are really getting in the way of multi-agency full approaches. I've put the Ekpat and Kent case on there because it's a very interesting case about the unaccompanied asylum-seeking children that went missing and the JR of the Home Secretary. What can we do? We can increase awareness of trafficking and exploitation. We need to try and identify it as early as possible. Please don't overlook it as a possibility. Consider using the NRM and local safeguarding if working with a potential victim. Obviously, if you're working for a local authority, you have a duty to use the NRM where you think you're dealing with a potential CCE victim. Remove assumptions about who may be a victim of CCE. More multi-agency working. Better understanding of trauma when working with children and their parents. And whenever there's a discussion of youth crime, please consider the context of that involving child exploitation. So here I've put my resources. Of course, please do email me if you've got any questions about the things that we've talked about today. And I will now stop sharing my screen and hand you over to Charlie. So Charlie is talking to you next. He is a financial remedies specialist. He was called to the bar in 2016.
Thank you, Laura. Good morning, everybody. Thank you for joining us for brunch without any food, but we'll manage. So this is called Questionnaires. What is fair in a questionnaire? I've chosen this really because it rhymes. There was an alternative title, which is Wretched Questionnaires. And I'm bolstered in this view by Alexander Chandler's 2019 article. He's far more senior than I am, and his article is called The Unbearable Pointlessness of the Questionnaire. And these can be highly contentious at first appointment and time-consuming at first appointments, but then often completely ignored afterwards. They're not referred to sometimes at all at final hearing or at FDR, but they do have their place. And it's important that the right questions are asked and that they are asked in the right way. It's part of being thorough. It's part of acting in the best interests of the client and appropriately scrutinize the case of the other side and ensure that any unexplained transactions which could lead to a suspicion of undisclosed assets are aired and then explained so that you can negotiate. In a rare case, you might also turn up some deliberate non-disclosure. And secondly, it's important that genuinely significant issues are explored in questionnaire rather than finding yourself at a final hearing being criticised for pursuing an issue at that final hearing that wasn't aired in the questionnaire. But I see a lot of questionnaires that are less than ideal and contain questions that really should not be in there, and the document is sometimes often too long. And as counsel, one sometimes gets the feeling of being thrown under the bus, attempting to defend questions that really shouldn't have been in there in the first place. And one view is, well, why does it matter? You know, let's stick the question in. It's worth a go, it's worth asking, and if the judge removes it, the judge removes it. That can backfire because the client may well feel that things haven't gone their way because the judge is against them on multiple issues, because their questionnaire is being hammered and ripped apart. and then you've got the job of trying to build them back up after the first appointment, and that needn't be the case. So I'm going to advance the slideshow, hopefully. There we go. I'm going to look at the legal framework and the rules underpinning these questionnaires, the guidance available for their use, their drafting, and resources, and also some examples, good and bad. And then there may be time for some questions after that. So, their function. Practice Direction 21A in the Family Procedure Rules provides that questionnaires are the second stage of disclosure. The first stage is for me with supporting exhibits. And then the third stage after the questionnaire is updating a disclosure ahead of FDR or ahead of the final hearing. So the disclosure process is controlled by the court. And here, this is an interesting rule, FPR 916. It says that between the first appointment and the FDR, a party isn't entitled to the production of any further documents, except in the accordance with directions given under Rule 915, which is the questionnaire, or with permission. So the questionnaire is supposed to be it, really, without further order. In practice, however, how does it work? It's common to request disclosure in correspondence on various issues once questionnaires have been answered. There may be some new developments. There may be something arising from an answer to a questionnaire. There may be something old that's only just come to light. So it's very common for these issues to come up. However, you're faced with this rule. Realistically, if you receive a request for disclosure in correspondence, you know that if you refuse, then there may be an application to court, and then you're likely to be exposed in costs if it's a reasonable request. And secondly, you don't want the other side to be raising issues of non-disclosure at FDR, because this is going to hurt your chances of settlement. It's best that you put these issues to bed. Hopefully the client's got nothing to hide, and you can respond with whatever it is that's being asked of you. So this 9.16 rule, I don't think, is a huge barrier in practice. And then these are the rules in the FPR about questionnaires. So it says here what they are. You have to file a questionnaire setting out by reference the concise statement of issues, any further information and documents requested from the other party, or a statement that no further information and documents are required. And at the first appointment, the court's going to determine the extent to which these questions are answered. There's nothing in there really about there's no other guidance. You think, okay, well, if the rule is part 9 of the FPR, Family Procedure Rules, surely we're looking at Practice Direction 9 for guidance on what should be in the questionnaire. Wrong. There's nothing in FDR, Practice Direction 9, except paragraph 5.2, which provides that a reply to questionnaire must be verified by a statement of truth, which isn't hugely helpful. So the Red Book comes to the rescue, and there is a paragraph, or a couple of paragraphs in the Red Book below Rule FPR 9.15, which provides some guidance. So the overriding objective determines that only relevant and necessary information will be ordered. Proportionality is the name of the game, and the court should take a broad, even, rough and ready attitude to the valuation of assets which are unlikely to make a significant difference to the overall value of the pot. And the High Court case of B&B in 2013 has started. Now, I thought, fantastic, there's High Court authority on questionnaires, but that case isn't about questionnaires. It is more broadly about proportionality, but it's still of value. And then the second paragraph is that the judge will determine which questions should be answered and in what manner. Questions that are irrelevant, oppressive, or more appropriately asked in cross-examination will be disallowed. Conversely, issues that may prove fatal to an FDR hearing, if not addressed in advance, may be properly directed in questionnaires. Questionnaires should, unless in a complex case or with a non-disclosing party, not exceed 4 pages. So that is some useful guidance. The answers have got to be relevant. The questions have got to be relevant. They can't be oppressive, and they shouldn't be cross-examination questions. they should be restricted. The questionnaire in total should be restricted to 4 pages. There's more guidance from the FRC efficiency statement, which says that the questionnaire should be size 12 font, size 1.5 spacing, so in common with other such documents, so that there is a restriction in length. There's some guidance as well on the on Lexis PSL, which is that care must be taken to ensure that the questions are not part of a phishing exercise for irrelevant or unnecessary information. And that comes from a very, very useful document, which is their specimen questionnaire in financial remedy applications. So that's a really, really excellent resource. And it's got a huge number of appropriate questions on an enormous number of issues, as well as guidance on each issue. And I would commend that document. Sadly, the terms of my Lexis license do not permit me to share it as part of this presentation, but I do commend its use. It's out there. It's really worthwhile looking at. And then we've got some suggestions made by Alexander Chandler KC in his article that I referred to earlier, The Unbearable Pointlessness of the Questionnaire, and it was published in the February 2019 edition of Family Law. So the first thing he says is think backwards from the final hearing. He's saying, think about the issues that are likely to be relevant at final hearing. What are we going to be asking questions about at final hearing? And use the questionnaire to tee those up. So the example he gives, for instance, is if income is an issue, why don't you ask for a mortgage application, a previous mortgage application? And then you will see what the other side said about their income at a time when it would have been favourable to have a higher income. If earning capacity is an issue, ask for a CV. Maybe even ask for a narrative on from that party on their earning capacity. And otherwise, you can end up in a situation where you're at final hearing, you're asking these questions in cross-examination, but the other side will say, well, you didn't address this in questionnaire. There was an opportunity, you didn't deal with it then. And that can cause you a problem. So think backwards is the first point. Secondly, there's no need to ask questions about stuff that is normally part of the first appointment order. So property particulars, evidence of mortgage raising capacity, even property valuation, they can all come out. They don't need to be in there. They can be the subject of directions at first appointment, either from the attended first appointment or agreed directions. Don't bother asking questions about schedules of outgoings. Alexander Chandler calls this a waste of time. I agree. They really amount to cross-examination. So there's one party's being asked, why do you spend so much at the hairdresser in the questionnaire? You could be far more effective in cross-examination at final hearing, dealing with that point. And you may feel that points are being scored by sticking these in the questionnaire and pointing out this obvious overspend in the other side's budget. In reality, my experience is in practice that this doesn't add any value at all. These point scoring exercises don't really help one's case at FDR or final hearing when it could be put across much better orally. The questionnaire cannot be used to seek documentation belonging to a third party. So you have to use Rule 21.2 instead. And there's no point asking questions about matters already covered in Form E. For instance, please confirm that the respondent has no other bank accounts. The respondent has already signed his Form E with a statement of truth, saying that the aforementioned is true. So you're just repeating yourself. I don't think it adds any value. Many judges will allow it in. I agree that it shouldn't be in there. A questionnaire should not be the opportunity to make comment about contentious material. So this is the cross-examination point. Setting out some issues one side has with the other, and then raising the temperature and trying to make a point on that. It's of little value and shouldn't be included. And think about the relevance of each question. I think it's common to ask for credit card statements. What's it going to? What are you trying to show? What are we likely to find in the credit card statements? This is, I think this plays into the fishing point. Credit card statements are asked for in order to just see what's in there and see if we can make any points out of the spending they're in. I mean, it might sometimes go to income, but it's of little value and may not be relevant. And this wasn't included in the article, but this is a suggestion of my own. I don't think it's appropriate to use the questionnaire to get to the other side to commit their position to paper on a certain issue. So one might be, does the respondent accept that the family home must be sold? They may do, they may not. That may change. Questionnaires are part of the disclosure process. They're evidential in nature. It's not appropriate then to use them to try and pin down the party's position on an issue, because the position may change. And you've got ES1, you've got open offers, you've got WP offers, you've got position statements. For me to set out the orders sought, set out that party's position on the various issues. So I don't think it's appropriate to use these documents for that purpose. So we'll turn now to some examples. Firstly, does the wife accept that the value of the family home is correctly valued at 483,000 by ex-chartered surveyors who specialise in agricultural, residential and commercial property and land? Now, my view that this is inappropriate because the valuation of property is better dealt with as part of the court's directions. There's also an element of cross-examination here, because we're told, the wife is told that the surveyors specialise in agricultural, residential and commercial property and land. It raises the temperature, it's point scoring, it's no business being in a questionnaire. Please confirm if the wife is purposefully delaying providing the husband with business post. Well, what's the value of that? What value does that add? Other than raising the temperature, it's not a request for information about financial circumstances. It's point scoring, and it reveals the scale of the acrimony in that case. So that is clearly not appropriate in a questionnaire. And please, can the applicant husband confirm whether he is cohabiting with any other individual? And the difficulty with this one is that For Me already contains a section where the applicant husband will have signed to say he's not cohabiting with anybody else, because you're supposed to put your cohabitant on there as well as an overview of their financial position. So if he hasn't done that, then he's signed a statement of truth saying that that's true. Repeating it doesn't really add any value. You do see this done sometimes if you're more specific, if you use a specific example. If you've got specific information about the alleged cohabitant, you may get some joy out of this, and then later on you can say, well, look, you said one thing on For Me and he said another in questionnaire, but technically the evidence is already there, the sworn evidence is already there that he's not cohabiting. And then he's still perjured himself, because your evidence that he is cohabiting, you can still hit him over the head with that, use against his sworn evidence on For Me. So it doesn't really need to be in there. The applicant is asked to confirm that whilst he suggests that it will be difficult for him to retain following the loss of his job in April, I think that means, retrain. The applicant is asked to confirm that whilst he suggests it will be difficult for him to retrain following the loss of his job in April 22, he has nevertheless found new employment with a higher income than his previous job. This is a cross-examination question. He said that he couldn't retrain and he lost his job, therefore his income is low. However, he's got new employment. Why did you say that you couldn't retrain? It doesn't add any value. It's cross-examination. It doesn't move the situation on at all. The applicant is specifically asked to confirm which holidays he paid for during the marriage. Who cares? it doesn't matter which holidays he pays for. The court is looking forwards to helping these parties separate themselves financially from each other and move on. It raises the temperature. It's cross-examination. It's no place on a questionnaire. The husband asserts that the dog's puppies are worth £2,000 each. Please provide copies of the passports for the dogs. And it's very difficult to understand what the relevance of that is. Why are the dogs' passports? What have they got to do with the value of the dogs? I think a better question would be, please provide valuation evidence. Please provide evidence of these dogs' value, rather than the passport. So that one isn't relevant. Now, I'm very sorry, by the way, if I've picked on anybody's in attendance, any of their work, but these are the ones that I was able to find going back through the last few months of my first appointment bundles. But this is quite a good example. There are multiple payments to female name as follows, and the payments are set out then over a period of time. £14,000, July to November of the same year. Husband is asked to explain the nature of these payments and provide documentary evidence. Now, this is better than what's often seen, which is, please explain these individual transactions, because here we've got the value, the amount, the total amount is totted up. So you can see, so the court can see that collectively this is quite a lot of money, and it's therefore I think it justifies an answer. And I think this is a better approach rather than just having the individual transactions there. So I think it's a worthwhile exercise, going back and adding them all up, and then you can show how significant these are over a period of time in the context of a case as a whole. So that is an example of a good question that I picked on. So that's what I had to say on questionnaires. Thank you all for listening. I think we do have some time for questions. I had a question in advance actually as well, which I'll deal with in a moment. But I think Laura wanted to go first and deal with some questions that she had.
Thanks so much, Charlie. So one of the questions I've been asked is, what should we do if we're concerned that a child or a young person is or has been a victim of exploitation? I would say that in this circumstance, your first point of call really is to try and liaise with your local authority social work team, find out whether or not they've made an NRM referral or DTN if it's an adult, whether they've been provided with intelligence from the police, which we often these days hear about, but it doesn't amount to police disclosure. So sometimes that intelligence from the police can really help, because it may well be from an NRM referral that some additional support can be provided to the potential victim. I'd also consider seeking advice from one of the very many specialist serious youth violence and exploitation or gang membership agencies, St Giles, CYP First. There really are loads and loads of them. And it's really heartening to see that a lot of local authorities are now setting up gang and serious youth violence prevention teams in-house. There really is so much more awareness and support of this over the last year. I think the other thing I would say is, if you have concerns, just be really, really mindful of how you interact with that person, that child. They will be highly anxious and traumatized. They will be living in absolute fear. And so the way that we deal with them can make a difference to whether or not they're able to engage with us or not. Over to you, Charlie.
Thank you, Laura. Right. Question I had in advance was how to deal effectively with evasive or incomplete replies. Schedule of deficiencies often elicits repeat obfuscation. Any anecdotes of practice direction 21A 2.4 being used, which is an order for specific disclosure, being effective. evasive, incomplete replies, the replying party is only ultimately hurting themselves, because following it through to FDR, to trial, if they haven't answered the questions properly, you can say non-disclosure, and the court can of course draw inferences. You've got NG and SG, the Mr. Justice Mostyn decision from 2011, which sets out the principles to be applied where the court satisfied that disclosure given by one party has been deficient, and also the Court of Appeal in Moa and Moa on the decision of Lord Justice Moylan. So the replying party leaves themselves exposed to potentially an indication that the court at final hearing may draw inferences, or an actual inference being drawn at final hearing. There was a recent example I did though in practice. There was it was a respondent. The wife had a book deal, and she'd been, I think, fairly coy about the potential income from the book, and we had to be very, very specific about what we wanted. So we worked out, okay, there would be a contract with the publisher, which should set out the commercial arrangements. So we were very, very specific about what we actually wanted, and that did in the end turn up at the 11th hour before FDR. But I think it's implied in that, or it was read to be implied in that correspondence asking for that disclosure, that an application for specific disclosure is something that you can do, so that the other side knows that. The other side knows that if you come to court and get that order, then they're exposed on costs. An application wasn't actually made in that case, but I think if an application would have been made, that would have been the outcome. We would have got the disclosure we wanted. There's another couple of tools. I think this goes to a couple of the other questions that have been asked. The Bankers Books Evidence Act, 1879, allows one to apply to the court for permission to inspect and take copies of entries in a banker's books, so essentially bank statements. So you can go and get those directly from the bank if there are ongoing legal proceedings. There was a question as well about pensions. So what happens if a spouse is insisting that the other spouse has got a pension? You can ask them to do use a pensions trace. So there's a resource on the government website which provides, which I think it only works on occupational pensions, but you type in your employers, you enter your previous employer into that, and they will give you the pensions arrangements of the pensions administrator for each employer, and they can then be approached to provide details of whether or not there is a pension. Laura.
Thanks, Charlie. The other question that I've received, one of the other questions is, what can I do to learn a bit more about becoming trauma informed? There's some really good resources on the Gov.uk website here. There's been pilot schemes in Wales that have borne tremendous fruit in terms of reducing harm there. I'd also really encourage anybody that's dealing with children cases of any form to look into learning empathic reasoning, which is essentially more than a passive understanding of another person's perspective. It encourages active engagement in their emotional experience. And the reason why this is so useful is because we're often faced with very, very upset or angry clients, and it's a way of allowing them to say what they need to say, but then reflecting back to them what you understand they are experiencing. And it's really extraordinary how quickly that can bring somebody down off the roof and help them to engage with you. The other recommendation I would make for anybody that's interested on the effects of trauma or how to work with it is to look at the work of Dr. Peter Levine. Really loads of his teachings are online, freely accessible. He's a real pioneer on trauma and its effects. So I would commend those to anybody interested in that issue. Your turn again, Charlie.
Thank you, Laura. I'll do one more from Alex Butler on the matter of some questions read cohabiting that may be cross-examination questions. How would he propose those questions are best put or answered for the purposes of negotiations without going to cross-examination at a final hearing? And that's a fair point, because we don't want to go to final hearing because the costs are ridiculous and the strain of it on the client is awful. An appropriate vehicle, if you really want to put all this evidence to the other side, say you've got good evidence that the other party is cohabiting, you can do that in correspondence. You can do that in open correspondence, set out, put your case in the correspondence there. You know, this is what we think is happening. This is the evidence we've got. We're pretty convinced that at final hearing, there would be a finding made that your client is cohabiting. We're putting you on notice of costs. Please give us the financial information of the cohabitee. That's how I would approach it. Keep it out of the questionnaire, because it muddies the questionnaire, I would say, and it's probably not the purpose of the questionnaire. But I think that's now all we've got time for. So it lands on me to say thank you everyone for attending. Thank you for your engagement. Lots of you here. Thank you for all the questions as well. We're not doing a brunch over the summer holidays. We will be back, well, not me, probably not Laura either, but somebody will be back on Thursday, the 26th of September. Before that, there's also the Southampton 3PB Southampton Care Conference, which is on Friday, the 6th of September. A booking link will be posted in the chat, and it'll also come out in a follow-up email. But thank you all very much for joining us this morning. And it's 12 o'clock, so good afternoon. Thank you.